Supreme Court of India Rajesh Viren Shah vs Redington, India, Limited decided on February 14, 2024 SEC Online SC 143 Facts of the case. The appellants, namely, Rajesh Viren Shah and Sanjay Babulal Batata respectively, were arraigned as accused in a complaint filed under Section 138 of the Negotiable Instruments Act, 1881 in relation to 3 checks which were dishonored on presentation. Appellants preferred a petition under Section 482 of the CRPC which was dismissed by High Court. Findings of the Court, Section 141 of the niact, which states that every person who at the time of the offense was responsible for the affairs/conduct of the business of the company, shall be held liable and proceeded against under Section 138 of the niact, with exception thereto being that such an act, if done without his knowledge or after him having taken all necessary precautions, would not be held liable. However, if it is proved that any act of a company is proved to have been done with the connivance or consent or may be attributable to 1. A director, 2. A manager, 3. A secretary, or 4. Any other officer, they shall be deemed to be guilty of that offense and shall be proceeded against accordingly ex facie. We find that the complainant has not placed any materials on record indicating complicity of the present appellants in the alleged crime, particularly when the appellants had no role in the issuance of the instrument, which is evident from Form 32, issued much prior to the date on which the check was drawn and presented for realization. The veracity of Form 32 has neither been disputed by the respondent nor has the act of resignation simpliciter been questioned. As such, the basis on which liability is sought to be fastened upon the instant appellants is rendered questionable. The record reveals the resignations to have taken place on December 9, 2013 and March 12, 2014. Equally, we find the checks regarding which the dispute has traveled up the courts to have been issued on March 22, 2014. The latter is clearly, after the appellants have severed their ties with the respondent company and, therefore, can in no way be responsible for the conduct of business at the relevant time. Therefore, we have no hesitation in holding that they ought to be then entitled to be discharged from prosecution. The judgments is set aside. Accordingly, all criminal proceedings pertaining to the instant appellants arising out of the complaints filed by the respondent herein are quashed. The appeals are therefore allowed.